The case of New Era Publications International, on Podselskab, plaintiff appellee / cross appellant, versus the Carroll Publishing Group, defendant appellant / cross appellee, case numbers 12041376 and 907181, dockets 907181 and 907193, was heard before the United States Court of Appeals for the Second Circuit. The arguments were heard on April 2, 1990, and the decision was rendered on May 24, 1990. The opinion is found in Federal Reporter 2nd Series, Volume 904, page 152, United States Statutes at Large Volume 58, page 2734, Copyright Law Decisions Volume for Year 1990, page 26579, United States Patent Quarterly Volume 14, page 2030 and Media Law Reporter Volume 17, page 1913. The Honorable Mr. Feinberg read the opinion of the court, which was as follows. Defendant Carroll Publishing Group appeals from a February 13, 1990, judgment of the United States District Court for the Southern District of New York, Judge Louis L. Stanton presiding, permanently enjoining it from publishing a biography in its present form, on grounds of copyright infringement. In an opinion reported at Federal Reporter 3rd Series, Volume 729, page 992, the District Court held that the biography's quotations from its subject's writings, all of which had been published, did not constitute "fair use" under Title 17 of the United States Code, Section 107, and that the copyright on one of the works quoted from had expired. We disagree with the former conclusion but agree with the latter, and thus reverse in part and affirm in part. Background. The biography at issue in this appeal is entitled A Piece of Blue Sky, Scientology, Dianetics and L. Ron Hubbard Exposed, and was written by Jonathan Caven Atack. We will refer to A Piece of Blue Sky as the book and to Caven Atack as the author. The subject of the book is L. Ron Hubbard, the controversial founder of the Church of Scientology, the Church, who died in 1986. The author joined the Church when he was 19 and was a member for almost 9 years. In 1983, however, according to the author, his faith in the Church was shaken by what he saw as the Church's repressive practices toward dissident members. The author subsequently resigned from the Church, but undertook a thorough investigation into the Church and Hubbard. During the course of this inquiry, the author became convinced that the Church was a dangerous cult, and that Hubbard was a vindictive and profoundly disturbed man. The District Court granted a permanent injunction. It held, first, that the copyright had expired on one of the works quoted in the book, the Hubbard Communications Office Manual of Justice. Federal Reporter 3rd Series, Volume 729, page 995. The court then went on to determine whether the book's use of passages from Hubbard's other works was protected "fair use" under Title 17 of the United States Code, Section 107, which is reproduced in the margin. Item at 995 to 1001. The District Court analyzed the 4 factors spelled out in Section 107, and found that Factor 1, purpose and character of the use, "strongly" favored appellee, because "many of the passages lack any allowable fair use purpose." Item at 998. Factor 2, nature of the copyrighted work, favored appellee since "so many" of the quoted passages "are expressive rather than factual." Item at 999. Factor 3, amount used in relation to copyrighted work as a whole, also favored appellee, because the quoted passages amount to a "small, but significant element of" the book. Item at 1000. And Factor 4, effective use on the market for the copyrighted work, did not favor either party. Item at 1001. The District Court thus concluded that appellee was entitled to a permanent injunction against publication of the book in its present form, noting that the book is still in manuscript form, so deletion of the infringing passages will be relatively simple and inexpensive. Item at 1001. The District Court thereafter entered judgment, listing 103 infringing passages taken from 43 works, all published. Appellant now appeals from the judgment granting an injunction, and appellee cross appeals from the District Court's determination that the copyright on the Hubbard Communications Office Manual had expired. Discussion. 1. Fair use. Appellant asserts that, contrary to the District Court's view, all 4 fair use factors referred to in Title 17 of the United States Code, Section 107, weigh in its favor, while appellee argues to the contrary. At the outset, we note that Section 107 requires a case-by-case determination whether a particular use is fair. Harper and Row, Publishers, Incorporated vs. Nation Enterprises, United States Supreme Court Reporter, Volume 471, page 539. Furthermore, fair use is a mixed question of law and fact, item at 560, and thus the district court's conclusion on this point is open to full review on appeal. See Puma Industries Consulting, Incorporated vs. Dahl Associates, Incorporated, United States Court of Appeals for the Second Circuit, Federal Reporter 2nd Series, Volume 808, page 982. And, quote, where the district court has found facts sufficient to evaluate each of the statutory factors, an appellate court need not remand for further fact-finding, unquote. Harper and Row, United States Supreme Court Reporter, Volume 471, page 560, quoting Pacific and Southern Company v. Duncan, United States Court of Appeals for the 11th Circuit, Federal Reporter 2nd Series, Volume 744, pages 1490 to 1495, Note 8, certiorari denied, United States Supreme Court Reporter, Volume 471, page 1004, West Supreme Court Reporter, Volume 105, page 1867, Lawyers Edition, 2nd Series, Volume 85, page 161. In addition, the structure of Section 107 is significant. The section is entitled, quote, Limitations on Exclusive Rights, Fair Use, unquote, and the opening sentence makes clear that a, quote, fair use, is not an infringement of copyright, unquote. The same sentence furnishes examples of broad categories of fair use, quote, criticism, comment, news reporting, teaching, scholarship or research, unquote. The section then defines 4 non-exclusive factors to be considered in determining whether a particular use is fair. We have quite recently applied the doctrine of fair use in 2 opinions of this court. See Salinger v. Random House, Incorporated, Federal Reporter 2nd Series, Volume 811, page 90, and New Era Publications International, Onpod Selskab v. Henry Holt & Company, Federal Reporter 2nd Series, Volume 873, page 576. Since the decisions in Salinger and New Era, there have been a number of articles on the subject of fair use. See, for example, Weinrib's article entitled Fair's Fair, a comment on the fair use doctrine, Harvard Law Review Volume 103, page 1137, 1990. Indeed, several of the articles have been written by some of the judges involved in those decisions. See Oak's article entitled Copyrights and Copy Remedies, Unfair Use and Injunctions, to be published in a forthcoming edition of the Hofstra Law Review, Laval's article entitled Commentary, Toward a Fair Use Standard, Harvard Law Review Volume 103, page 1105, 1990, Miner's article entitled Exploiting Stolen Text, Fair Use or Foul Play? Journal of Copyright Society Volume 37, page 1, 1989, and Newman's article entitled Not the End of History, The Second Circuit Struggles with Fair Use, Journal of Copyright Society Volume 37, page 12, 1989. Some of these articles are highly critical of the state of the law with respect to the fair use doctrine and offer suggestions for improvement. But, our task is to apply as best we can the teachings of the governing precedents as we understand them. In doing so, on the facts before us and under the appropriate wide-ranging standard of review, we conclude that all 4 factors listed in Section 107 favor appellant, and that appellant's use was fair. A. Factor 1, Purpose and Character of the Use. As noted above, the book is an unfavorable biography. Section 107 provides that use of copyrighted materials for, quote, purposes such as criticism, scholarship, or research, unquote, is not an infringement of copyright. Our cases establish that biographies in general, and critical biographies in particular, fit, quote, comfortably within, unquote, these statutory categories, quote, of uses illustrative of uses that can be fair, unquote. Salinger v. Random House, Incorporated, Federal Reporter 2nd Series, Volume 811, page 90, and New Era Publications International, Onpod Selskab v. Henry Holt & Company, Federal Reporter 2nd Series, Volume 873, page 576. Citing Harper and Row v. Nation Enterprises, United States Reports Volume 471, page 561, Supreme Court Reporter Volume 105, page 2231, appellee argues that there is no rule that if an allegedly infringing work is a biography, Factor 1 necessarily operates in the biographer's favor in evaluating whether there has been a, quote, fair use, unquote. Nevertheless, quote, if a book falls into one of these categories, i.e., criticism, scholarship or research, assessment of the first fair use factor should be at an end, unquote. New Era Publications International, Onpod Selskab v. Henry Holt & Company, Federal Reporter 2nd Series, Volume 884, page 661, opinion of Judge Miner, concurring in the denial of rehearing in bank. True, The Supreme Court in Harper and Row did not end its analysis of Factor 1 once it had determined that the allegedly infringing news reporting, was listed in Section 107 as an example of fair use. See United States Reports Volume 471, page 561-563, Supreme Court Reporter Volume 105, page 2230-2232. However, what the court went on to consider was the infringer's knowing exploitation of the copyrighted material, obtained in an underhanded manner, for an undeserved economic profit. See item. The present case, by contrast, does not involve, quote, an attempt to rush to the market just ahead of the copyright holder's imminent publication, as occurred in Harper and Row, unquote. Salinger vs. Random House, Incorporated, Federal Reporter 2nd Series, Volume 811, page 96. Instead, as the author explained in detail in an affidavit submitted below, discussing the reason why he included each quote, the author uses Hubbard's works for the entirely legitimate purpose of making his point that Hubbard was a charlatan and the church a dangerous cult. To be sure, the author and appellant want to make a profit in publishing the book. But the author's use of material, quote, to enrich, unquote, his biography is protected fair use, quote, notwithstanding that he and his publisher anticipate profits, unquote. Idem. Appellee also contends that the book's use of Hubbard's works does not serve any fair use purpose, but was rather unnecessary appropriation of Hubbard's literary expression. We do not agree with this characterization. The author uses the quotations in part to convey the facts contained therein, and not for their expression. More importantly, even passages used for their expression are intended to convey the author's perception of Hubbard's hypocrisy and pomposity, qualities that may best, or only, be revealed through direct quotation. The book, quote, is not merely the product of the facile use of the scissors, unquote. Maxstone Graham vs. Burt Kale, Federal Reporter 2nd Series, Volume 803, page 1253, Supreme Court Reporter Volume 481, page 10059, 1986, and Folsom vs. Marsh, Federal Cases Volume 9, page 342, Circuit Court of Massachusetts, number 4901, 1941. Appellee points particularly to the 17 topic quotations that begin many of the chapters. While a few of these may arguably come close to the line separating critical study from appropriation, most do not. Indeed, even this borderline use appears to serve the author's purpose by juxtaposing the grandiose expression of the quotations with the banal, to the author, material contained in the body of the chapter. Moreover, the topic quotations sometimes serve to explain or to summarize matters discussed in the chapter. Appellee further argues that New Era Publications International, Onpod Selskab vs. Henry Holt & Company, Federal Reporter 2nd Series, Volume 873, page 576, explicitly held that copying for purposes of demonstrating character defects cannot amount to fair use. This is simply a misreading of New Era. The passage that appellee cites in support of its interpretation, Federal Reporter 2nd Series, Volume 873, page 583, does not reject the idea that quotation in a biography to demonstrate character flaws may be fair use. Rather, the passage rejects the claim that the purpose of the use entitles it to, quote, special consideration, unquote. See also New Era Publications International, Onpod Selskab vs. Henry Holt & Company, Federal Reporter 2nd Series, Volume 884, page 659, minor, judge, concurring in the denial of rehearing in bank. The panel in New Era, however, observed that, quote, as long as a book can be classified as a work of criticism, scholarship or research, as can the book here, the factor cuts in favor of the book's publisher, whether the copyrighted matter is taken from a literary lion like J.D. Salinger or a purported prophet like L. Ron Hubbard, unquote. New Era Publications International, Onpod Selskab vs. Henry Holt & Company, Federal Reporter 2nd Series, Volume 873, page 583. We hold that Factor 1 favors appellant. B. Factor 2, Nature of the copyrighted work. The district court found that all of the works from which the author quoted had been published. Whether or not a work is published is critical to its nature under Factor 2, because, quote, the scope of fair use is narrower with respect to unpublished works, unquote. Harper and Row, United States Supreme Court Reporter, Volume 471, page 564, 1985, and New Era, Federal Reporter 2nd Series, Volume 873, page 583. Thus, quote, even substantial quotations might qualify as fair use in a review of a published work, unquote. Harper and Row, United States Supreme Court Reporter, Volume 471, pages 564-5. Furthermore, the scope of fair use is greater with respect to factual than non-factual works. See Idem at 563, 1985. While there is no bright line test for distinguishing between these two categories, we have referred to the former as works that are, quote, essentially factual in nature, unquote. Maxstone Graham vs. Gordon, Federal Reporter 2nd Series, Volume 803, page 1263, 1986, or, quote, primarily informational rather than creative, unquote. Consumers Union of United States, Incorporated vs. General Signal Corporation, Federal Reporter 2nd Series, Volume 724, page 1044, 1983. We have some hesitation in trying to characterize Hubbard's diverse body of writings as solely, quote, factual, unquote, or, quote, non-factual, unquote, but on balance, we believe that the quoted works, which deal with Hubbard's life, his views on religion, human relations, the church, etc., are more properly viewed as factual or informational. Apelli emphasizes, however, that there is no per se rule under Harper and Row, New Era and Salinger that Factor II favors an alleged infringer whenever the works quoted from are published, as Appellant appears to suggest. Apelli is, of course, correct that there is no rule that one may copy with absolute impunity from a published work, regardless of the amount taken. Nevertheless, Hubbard's works have been published, and, quote, biographies, of course, are fundamentally personal histories, and it is both reasonable and customary for biographers to refer to and utilize earlier works dealing with the subject of the work and occasionally to quote directly from such works, unquote. Maxstone Graham, Federal Reporter 2nd Series, Volume 803, page 1263, 1986. Apelli also contends that Harper and Row intended to allow liberal quotation only for the purpose of literary criticism or review of published works, and that the book does not purport to analyze the literary worth of Hubbard's works. But, we regard Apelli's attempt to limit Harper and Row to literary criticism as entirely too literal-minded, particularly in the face of our cases holding that biographies are considered works of criticism, scholarship or research within the meaning of Section 107. See, for example, Salinger, Federal Reporter 2nd Series, Volume 811, page 96. Apelli further asserts that many of the quoted passages are more creative or expressive than factual, and that Maxstone Graham is not relevant here because that case involved, quote, standard social science source materials, unquote, i.e., quotations drawn from published interviews. We agree, as already indicated, that there is no easy distinction between works that are, quote, factual, unquote, on the one hand, and, quote, creative, unquote, or, quote, expressive, unquote, on the other, because, quote, creation of a non-fiction work, even a compilation of pure fact, entails originality, unquote. Maxstone Graham, Federal Reporter 2nd Series, Volume 803, pages 1262 to 1263, 1986. Thus, reasonable people can disagree over how to classify Hubbard's works. Nevertheless, although some of the quoted passages can accurately be described as expressive, for example, Hubbard's poetry, our review of the record persuades us that most simply cannot be so characterized. Finally, Apelli distinguishes Maxstone Graham, rightly noting that the case involved quotations from, quote, a collection of verbatim interviews, unquote, which the district court there described as, quote, essentially repertorial in nature, unquote. Maxstone Graham, Federal Reporter 2nd Series, Volume 803, page 1262, 1986. Nevertheless, we see nothing in that case indicating that the panel intended its discussion of Factor II to be limited to situations involving such interviews. Indeed, the panel drew its discussion of Factor II from an earlier case dealing with biographies, Rosemont Enterprises, Incorporated vs. Random House, Incorporated, Federal Reporter 2nd Series, Volume 366, page 303, 1966, certiorari denied, United States Reports Volume 385, page 1009, West Supreme Court Reporter Volume 87, page 714, Lawyers Edition 2nd Series, Volume 17, page 546, 1967. We conclude that Factor II favors appellant. C. Factor III, Volume of Quotation. Factor III addresses the amount and substantiality of the portion used in relation to the copyrighted work, not to the allegedly infringing work. Harper and Row, United States Supreme Court Reporter, Volume 471, page 564, 1985, and New Era, Federal Reporter 2nd Series, Volume 873, page 583. Quote, there are no absolute rules as to how much of a copyrighted work may be copied and still be considered a fair use, unquote. Maxstone Graham vs. Gordon, Federal Reporter 2nd Series, Volume 803, page 1263, 1986. This factor has both a quantitative and a qualitative component, so that courts have found that use was not fair where the quoted material formed a substantial percentage of the copyrighted work. See, for example, Salinger, Federal Reporter 2nd Series, Volume 811, page 98. Factor 3 favors copyright holder where 1/3 of 17 letters and 10% of 42 letters used, or where the quoted material was, quote, essentially the heart of the copyrighted work, unquote. Harper and Row, United States Supreme Court Reporter, Volume 471, page 565, West Supreme Court Reporter Volume 105, page 2233, quoting the District Court for the Southern District of New York's opinion in that case, Federal Supplement Reporter, Volume 557, pages 1067 to 1070, 1983. Here, the book uses overall a small percentage of Hubbard's works. Appellant calculates that the book quotes only a minuscule amount of 25 of the 48 works that appellee claimed were infringed, 5 to 6% of 12 other works and 8% or more of 11 works, each of the 11 being only a few pages in length. Appellee has accepted these figures, quote, for purposes of discussion, unquote, although it adds that they may understate the true amount taken. In the context of quotation from published works, where a greater amount of copying is allowed, see Harper and Row, United States Supreme Court Reporter, Volume 471, page 564, 1985, this is not so much as to be unfair. Maxstone Graham, Federal Reporter 2nd Series, Volume 803, page 1263, 1986, inclusion of 4.3% of published copyrighted work is not incompatible with a finding of fair use, or Iowa State University Research Foundation, Incorporated vs. American Broadcasting Company, Federal Reporter 2nd Series, Volume 621, page 57, 1980, fair use defense not available where broadcast was made containing 8% of a videotape that apparently had never been broadcast before. Nor is the use qualitatively unfair. Appellee asserts that, quote, key portions, unquote, of Hubbard's works are taken, quote, in many cases, unquote. But the district court found that the quotations in the book's text, which amount to the bulk of the allegedly infringing passages, do not take essentially the heart of Hubbard's works. New Era, Federal Reporter 2nd Series, Volume 873, page 1000, 1983, and our review of the remaining 17 passages, which are, quote, set off by themselves at the beginning of a part or chapter, unquote, unquote, set the tone for the sections they precede, unquote, persuades us that they too do not take essentially the heart of Hubbard's works. Appellee also argues that Factor 3 weighs in its favor because the quotations are an important ingredient of the book, pointing out that 2.7% of the book is made up of quotations from Hubbard's works. Appellee asserts that, because of the length of Hubbard's works and because so many of his writings were quoted from, it would be of little value to focus on the amount of infringing material in relation to the copyrighted works, and cites various cases, for example, Harper and Row, United States Supreme Court Reporter, Volume 471, page 566, 1985, Salinger, Federal Reporter 2nd Series, Volume 811, pages 98 to 99, Maripol vs. Neeser, Federal Reporter 2nd Series, Volume 560, page 1061, 1977, Certiorari denied, United States Reports Volume 385, page 1009, West Supreme Court Reporter Volume 87, page 714, Lawyers Edition 2nd Series, Volume 17, page 546, 1977, in which courts discuss the amount used in relation to the infringing work, not the infringed work. We do not agree with Appellee's argument. Section 107 plainly commands us to consider, quote, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, unquote, and contains no exception for lengthy works or quotations from multiple works. Furthermore, to the extent that courts have looked to the infringing work, the use here is not as significant as the use alleged in those cases. In Salinger, for example, the quoted materials, quote, to a large extent, unquote, made the book worth reading. Federal Reporter 2nd Series, Volume 811, page 99. By contrast, the use of the quotes here is primarily a means for illustrating the alleged gap between the official version of Hubbard's life and accomplishments, and what the author contends are the true facts. For that purpose, some conjuring up of the copyrighted work is necessary. See Cliff's Notes, Incorporated vs. Bantam Doubleday Dell Publishing Group, Incorporated, Federal Reporter 2nd Series, Volume 886, pages 490 to 497. This was a Second Circuit trademark case, where the court noted that parody, quote, must to some extent resemble the original, unquote. We find that Factor 3 favors appellant. D. Factor 4, Effect on the market. Factor 4 of Section 107 of the United States Code concerns the quote, effect of the use upon the potential market for or value of the copyrighted work, unquote. According to the Supreme Court, this quote, is undoubtedly the single most important element of fair use, unquote. Harper and Row v. Nation Enterprises, United States Reports Volume 471, page 561, West Supreme Court Reporter Volume 105, page 2233, footnote omitted. In evaluating this factor, courts do not focus solely on the market for the work itself, but also on the quote, harm to the market for derivative works, unquote. Item at 568, West Supreme Court Reporter Volume 105, page 2234. Appellee argues that Factor 4 favors it, asserting that it intends to publish an authorized biography of Hubbard that will include excerpts from all of his works, including material as yet unpublished, and that the book will discourage potential readers of the authorized biography by conveying the flavor of Hubbard's writings. Appellee also contends that New Era Publications International, Onpod Selskab v. Henry Holt & Company, Federal Reporter 2nd Series, Volume 884, page 661, opinion of Judge Minor, concurring in the denial of rehearing in bank, left us no choice but to rule in its favor on Factor 4. According to appellee, that case held that publication of a similar unfavorable biography would impair the market for, and compete with, its planned biography of Hubbard. We do not find either argument persuasive. As to the first, we found it quote, unthinkable, unquote in Maxtone Graham v. Gordon, Federal Reporter 2nd Series, Volume 803, page 1264, that potential customers for plaintiff's copyrighted book containing a quote, series of sympathetic interviews on abortion and adoption, unquote, would fail to purchase plaintiff's book because a small portion of it was used in an essay sharply critical of abortion. Item at 1264. Similarly, we are skeptical here that potential customers for the authorized favorable biography of Hubbard in the future will be deterred from buying because the author's unfavorable biography quotes from Hubbard's works. Indeed, it is not quote, beyond the realm of possibility that, unquote the book quote, might stimulate further interest, unquote in the authorized biography. Item. Furthermore, even assuming that the book discourages potential purchasers of the authorized biography, this is not necessarily actionable under the copyright laws. Such potential buyers might be put off because the book persuaded them, as it clearly hopes to, that Hubbard was a charlatan, but the copyright laws do not protect against that sort of injury. Harm to the market for a copyrighted work or its derivatives caused by a quote, devastating critique, unquote that quote, diminished sales by convincing the public that the original work was of poor quality, unquote is not quote, within the scope of copyright protection, unquote. Consumers Union of United States, Incorporated vs. General Signal Corporation, Federal Reporter 2nd Series, Volume 724, page 1051, footnote omitted. This is so because the critique and the copyrighted work serve quote, fundamentally different functions, by virtue, unquote of, among other things, quote, their opposing viewpoints, unquote. Maxtone Graham v. Gordon, Federal Reporter 2nd Series, Volume 803, page 1264. Quote, where the copy does not compete in any way with the original, unquote copyright's central concern, quote, that creation will be discouraged if demand can be undercut by copiers, unquote, is absent. Consumers Union of United States, Incorporated vs. General Signal Corporation, Federal Reporter 2nd Series, Volume 724, page 1051, footnote omitted. Here, the purpose of the book is diametrically opposed to that of the authorized biography. The former seeks to unmask Hubbard and the Church, while the latter presumably will be designed to promote public interest in Hubbard and the Church. Thus, even if the book ultimately harms sales of the authorized biography, this would not result from unfair infringement forbidden by the copyright laws, but rather from a convincing work that effectively criticizes Hubbard, the very type of work that the Copyright Act was designed to protect and encourage. Nor do we believe that New Era Publications International, Onpod Selskab v. Henry Holt & Company, Federal Reporter 2nd Series, Volume 884, page 661, opinion of Judge Minor, concurring in the denial of rehearing in bank, compels a contrary result. At the outset, we note that the panel in New Era did not address in this context the point we have just made, that is, a critical biography serves a different function than does an authorized, favorable biography, and thus injury to the potential market for the favorable biography by the publication of the unfavorable biography does not affect application of Factor 4. See Federal Reporter 2nd Series, Volume 884, page 683. Beyond that, However, New Era involved the publication of previously unpublished material, quote, particularly from Hubbard's early diaries and journals, unquote. Item at 578 to 579. Arguably, then, the unfavorable biography in New Era threatened economic harm to the authorized biography, even though it fulfilled a different function, because it contained material whose market value, 1, had not yet been realized by the copyright holder, and, 2, might be entirely misappropriated by the infringing publication. Here, by contrast, the works quoted from are all published, and the book will not tap any sources of economic profit that would otherwise go to the authorized biography. See Harper and Row vs. Nation Enterprises, United States Reports Volume 471, page 562, 567 to 568, West Supreme Court Reporter Volume 105, page 2231, 2234, regarding an unpublished work, actual damage of $12,500 shown, and infringing work intended to scoop publication of copyrighted work, Salinger vs. Random House, Incorporated, Federal Reporter 2nd Series, Volume 811, page 99, regarding unpublished letters, infringing work quote, copies virtually all of the most interesting passages of the letters, unquote. We conclude that Factor 4 favors appellant. Other factors. The factors enumerated in Section 107 are, quote, not meant to be exclusive, unquote. Harper and Row, United States Reporter, Volume 471, page 560, West Supreme Court Reporter, Volume 105, page 2030. We have looked to such additional considerations as bad faith by the user of copyrighted material that suggests unfairness, Maxstone Graham, Federal Reporter, 2nd Series, Volume 803, page 1264, or prejudice suffered by the alleged infringer as the result of the copyright holder's unreasonable and inexcusable delay in bringing the action, New Era, Federal Reporter, 3rd Series, Volume 873, page 584. Although appellee argues that the book's use of passages from Hubbard's works was quote, predatory, unquote, rather than fair, we simply do not agree with this characterization, and find that there are no additional factors suggesting unfairness. In sum, balancing all of the relevant factors, we believe that the present case presents a strong set of facts for invoking the fair use defense. The book is a critical biography, designed to educate the public about Hubbard, a public figure who sought public attention, albeit on his own terms. The book quotes from merely a small portion of Hubbard's works and from only those that have been published, and it will cause no adverse impact protected by the copyright law on the market for Hubbard's writings. In these circumstances, we conclude that the book's use of passages from Hubbard's work is protected fair use. On its cross-appeal, appellee argues that the district court erred in ruling that the Hubbard Communications Office Manual of Justice, 18 passages from which are quoted in the book, had been published in 1959 and that its copyright had expired. Appellee asserts that the Hubbard Communications Office Manual was subject only to quote, limited, unquote, publication in 1959, that the copyright notice appearing in the work, quote, copyright, c. 1959 by L. Ron Hubbard, all rights reserved, unquote, was incorrect and superfluous because the book was not published, and that the book did not come under federal copyright protection until January 1, 1978, the effective date of the 1976 Copyright Act. We are not persuaded by these arguments, which, according to appellant, were not raised below. The district court's finding that the Hubbard Communications Office Manual was published in 1959 is supported by evidence placed in the record by appellee itself, in particular, an affidavit stating, among other things, that the Hubbard Communications Office Manual was published. Since the Hubbard Communications Office Manual was published in 1959, there is no question that its copyright expired in 1987. Under Section 304A of the United States Code, any copyright that was in its first term on January 1, 1978, quote, shall endure for 28 years from the date it was originally secured, unquote. The date that the copyright of the Hubbard Communications Office Manual was, quote, originally secured, unquote, is governed by the provisions of the 1909 Copyright Act. Under Section 10 of the 1909 Act, an author, quote, secure copyright for his work by publication thereof with a notice of copyright, unquote, and Section 19 of that Act specified that the notice of copyright, quote, shall include also the year in which the copyright was secured by publication, unquote. Here, the Hubbard Communications Office Manual's copyright notice states 1959 as the copyright date. Thus, the Hubbard Communications Office Manual's copyright lasted for 28 years from 1959, United States Code, Section 304A, and expired in 1987. Conclusion. We hold that each of the four factors of Section 107 favors appellant, and that the book's use of quotations from Hubbard's published works was protected fair use. We also hold that the District Court did not err in finding that the copyright on the Hubbard Communications Office Manual expired in 1987. We thus reverse the judgment of the District Court, except to the extent it concludes that the copyright on the Hubbard Communications Office Manual expired in 1987, as to which we affirm. Footnote 1. We note here what should be obvious but nevertheless bears stating. We express no view of our own as to Hubbard, his teachings or the Church. The unflattering characterizations are those of the author of the book. Footnote 2. Section 107 provides that, quote, notwithstanding the provisions of Section 106, the fair use of a copyrighted work, including such used by reproduction in copies or phonorecords or by any other means specified by that section, for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research, is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include 1. The purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. Unquote. Footnote 3. Appellant puts the sum at 2.4% or 2.9%. The difference, however, is not significant to our reasoning, and we will use appellee's figure for the purpose of our discussion.